Welcome everybody to Venable's webinar, Small Business Change, Opportunities, Risk, and Realities. I'm so pleased today to have with me Emma Sutko. She's the founder and Chief Executive Officer of Potomac Wave Consulting. You know, I've known Emma for years, and she's the perfect person to talk about the realities and opportunities, and also just from a business side, the risk of owning your own small business. Emma started her women-owned small business, Potomac Wave, when there weren't as many opportunities for women-owned small businesses. And since then, she's really just taken it from a startup to, you know, one of the top small businesses. They've been recognized in Washington Technology's Fast 50 list, the top 20 for 3 years in a row. They've been recognized in the Washington Business Journal's #6 slot for growth in 2015, and as a DHS Small Business Achievement Award recipient. Now, you know, Emma started her company with a deep background already and deep experience in consulting engagements in the technology and government sectors. And I think when you're starting your own small business, obviously it's really good to have deep experience in what you know. And so without further ado, I'm going to turn it over to Emma to say a little bit about herself and her company.
Thanks, Becky. I appreciate the introduction, and I'm excited to be here today with everyone via this webinar. As Becky mentioned, I started my company, was the first employee of my company, and it's 11 years later. We've grown to about 60 million in revenue and around 250 employees. And in the last 11 years, we have navigated some incredible events in federal government, you know, spanning different types of requirements that the government has been issuing RFPs for in Homeland Security and Defense, as well as some of the civilian sector opportunities. And, you know, as Becky mentioned, you know, we've had to navigate a lot of these, you know, different events that have occurred from a legislative perspective to regulatory perspective to just federal contracting and business law perspective. So I'm looking forward to commenting on, you know, some of the discussion today and offering my perspective on that. And without further ado, hand it back to Becky to get into some of the nuts and bolts here.
All right, thank you so much, Emma. And before I get on to the substance, I just want to say just a quick bit about myself. I was an active duty judge advocate in the Air Force for 10 years. I spent most of my time in contracts. I was a program attorney for the AWACS as well as other electronic systems programs out of Hanscom Electronic Systems Center. And then I moved to after getting my LLM in procurement law, I moved to the trial team. So I saw the litigation end of everything. And then in 1999, which is a few years ago, I came over to Venable. And since being at Venable, I have done a lot of the small business issues, and I've really seen a change in both the opportunities that are available for small business, but also, you know, the velvet glove sometimes holds an iron fist on the back of its hand, right? So when I started, the SBA was a kinder, gentler, the regulations weren't as clear, and it left more room for small businesses to navigate ambiguities. Since then, people have been frustrated, or there's been a perception in Congress in particular that small businesses who aren't small are taking advantage of the small business rules and need to leave it to the small businesses. So I would say over the past 5 years in particular, we've seen a rapid codification of the rules. They're much more, they're clearer than they used to be, for one, but also when we get to the All Small program, you'll see that there's also a lot of certification requirements that they're trying to build in to make sure that everybody really is complying. So today, we're going to go over some of the legal issues that I see the most. And the biggest one really starts with affiliation. That is your biggest risk, I believe, as a small business. We're going to talk about that. We're going to talk about some of the opportunities in the SBA Mentor-Protégé program for all small as well as for 8A. And then some changes regarding recertification and status, changes or corrections depending upon whether you're the SBA or anybody else, and also some loan changes as well as the legal risk, and then Emma's going to cover the business challenges. So let's start off with affiliation. By the way, I should have said at the beginning, if you have questions, go ahead and type them into the webinar. What's going to happen, we're going to answer all your questions at the end, so we're going to write them down, but go ahead and as you think of them, type them in. We'll get to them at the end though. So we'll start with the most, I would say, codified portion, the easiest portion to understand about affiliation, which is stock ownership. By the way, affiliation is really means the power to control. So we're going to go over some discrete areas that the SBA covers, but never forget about that catch-all, which is the totality of the circumstances. So if you've thought of a way to have control, if you're other than small business and you've thought of a way to have control other than what's listed here, if the SBA determines that that actually is control, they can still say, well, it's the totality of the circumstances. But we'll start with stock ownership. I say stock ownership, but really that means it could also be a membership interest in an LLC. It means ownership. So if you're a person, concern, or entity that has the power to control 50% or more of the voting stock, you have control. And so if you have control in that way and you're not small, then that's a big issue. You're not a small business. Additionally, someone who is other than a small business who has a block of voting stock that's less than 50% but is large compared to all the other outstanding blocks, then you are not small. That is control. So there's also a present effect rule in there where things like stock options are deemed exercised. So even though as a business owner you might not have the ability to exercise that stock option right now, when they're looking at whether you're small or not, it's exercised, whether you could touch it legally or not. So that's important to understand who's in control in stock ownership. Of course, if you're small and you're all those things, good for you. You control your company. That is, as a small business, that is the most important thing that you can do. Control your company. Be in real control, not just don't allow yourself to become somebody's puppet, basically. So another control issue is common management. And so if you have common management with a business or concern that's other than small and you have overlapping officers or directors, or if you have the overlapping board of directors and those board of directors have control over the organization, you're an affiliate, or SBA is going to view you as an affiliate. So those are ones that I would say are more binary look. You know, either you have these under the rules or you don't. It's almost mathematical, right? But if you get down to these other issues of indicia of affiliation, they're a little more flexible. We'll start with identity of interest and family members, because look, a lot of times entrepreneurship runs in a family. Some of the best, smartest, real small business, independent business owners had a parent or maybe even a sibling that's also entrepreneurial and also owns a business. Now, you're going to go into that knowing there is a presumption that you're affiliated with married couples, parties to a civil union, parents, children, and siblings. Anybody in that category is automatically presumptively affiliated. It doesn't mean that they're actually affiliated, but what it does mean is that if you're going to have a small business and you have another family member that's in that category, you need to think about whether or not you can demonstrate a fracture, meaning that the businesses are absolutely separate and one business doesn't have the ability to control the other. It doesn't mean you have to just not get along with the parent or sibling or, you know, partner in a civil union to show that there's a fracture. You don't have to show a divorce. But it does mean a few things that they're going to look at. One is, are you in the exact same line of business? If you're thinking about starting a business and you have a family member who's already in business and is other than small, you might want to think about, let's go into a different NAICS code, go into a different line of business, because the first thing that they're going to look at is, are you in the same line of business? Now, that's not necessarily determined. I guess you could be in the same line or similar lines of business if you show other fracture elements. The other thing is, look, if you're a child and your parent has a really nice, who's other than a small business, has a really awesome office space, and they offer you space in their office space, turn it down. Get your own physical space. That's one of another big issue that the SBA looks at. Are you in physically the same location? So be in separate locations if you're going to trigger this. And then the other issues are really common sense. Do you do a lot of subcontracting back and forth? If you're in a presumptively affiliated category, I would urge you to do as little subcontracting as possible, not to share employees, and certainly not to share management. All those will be issues that they look at in determining whether there's a fracture. So we're going to also go to economic dependence. So the SBA has a presumption that if the small business concern, or SBC, derives 70% or more of receipts from another concern over the prior 3 fiscal years, then they are economically dependent. And of course, that can be broken. For example, if you're a startup, you're not, it'd be great if you could start with many diverse customers. But a lot of times, startups have 1 or 2 customers, and then they build their customer base from there. So if you're doing a 3-year look back and, one customer has a really, really significant amount of business that exceeds 70% in the beginning, but you can show that you've diversified your customer base over a period of time, that's a good way that you can show, hey, look, this presumption really shouldn't apply. They were just our first customer for the first year, but look, we're now diverse. And another thing, and Emma might want to comment on this later, but a lot of small businesses, when they do startups, they start off partnering on the subcontracting level. Now, you can still have some of the penalties we're going to talk about later on, the civil false claims, at a subcontracting level. So I'm not saying you can be affiliated and nobody cares. What I'm saying, though, is that there is less opportunity to challenge affiliation at the subcontracting level. So that's where many small businesses get their start, with some large businesses who want to subcontract out to smaller businesses. And another issue that's really important in affiliation is the issue is not, are you going to, as a small business, receive a size challenge? Just anecdotally, most of my small business clients at one time or another receive a small business size challenge. And the reason for that is it's the cheapest way to try to overturn a procurement. Because unlike at the GAO or in a bid protest over challenging the actual procurement decision, the SBA does all the work. All you have to do is say, hey, I think XYZ company is not small, and competitors know this. Also, and you probably know this if you're in small business or any business, is that the marketplaces, especially in government contracts, can be small. Your employees might talk to other employees. People know a lot about their competitors. And so many times people will know, oh, hey, I think XYZ is cheating. If they win this award and I'm up against them, I'm going to go ahead and challenge that. Easy to do, and there's really no penalty for being wrong. So I guess all that means, expect a size challenge. And so another important one is that's challenging for startups is a newly organized concern. So if you have one company and, a lot of its officers, directors, owners, or management leave to form another company, the SBA is going to look really carefully at that. And they're going to also look, are there contracts, bonds, or financial or technical assistance flowing back and forth between the companies? It doesn't mean you have to have a total fracture, but again, really make sure that you, especially if you're coming from organization that's not small and you're trying to create your own small business, you really want to limit much more than not just the 70% rule. You probably want to get, if you can, like under 20% of your revenues from that former company, and you want to show that you're financially independent. The other big category is ostensible subcontractor. So if you're a small business prime, that's great, you won your prime contract, but you need to perform the primary and vital portions of that contract. And probably everybody on this phone knows anecdotally of some business where it looks like they're small, but everybody really knows they're being controlled by a large business. Well, that's dangerous for the large business as well as the small business, because that makes you susceptible to challenge. And the SBA, in determining whether or not the small prime is really a subcontractor, is going to look at, the most important thing is who's really performing those vital portions of the work. And the vital portion of the work is not the administrative support, it's not the HR support, and it's not the accounting. So it means the meat of it. I mean, it could be accounting if accounting is what the business is that the government's buying, but it's got to be the primary thing that's being purchased. The other thing that the SBA looks at is, hey, who chased this work? If the large business subcontractor is the one who chased the work, went after the work, wrote the proposal, those are all things that the SBA is going to look at. And if you're in that situation, you're at risk of being considered affiliated. Finally, we've already talked about the sort of the catch-all, the bucket category, totality of circumstances. And what the SBA looks at here, really, the power to control. It's something other than what they've already thought of, but the interactions are so suggestive of reliance and control as to render them business affiliates. Is that a broad standard? Well, yes, it is. And actually, this one I have not seen the SBA abuse a ton. Some of the other ones I think they will be more likely to challenge, but it's where they start going through, and even though not one particular element that might suggest control is really significant enough to suggest control, there's just so many of them it looks like there's reliance or control. So that's it for affiliation, and we're going to move on to, well, that's it for the big categories of affiliation. The other really big challenge that I see for small businesses is, how are you going to get your investment, right? And a lot of times that means having good minority business partners to be part of your organization. And if you're a smart business person and you're a large business, or other than small, you're going to want to make sure you have some assurances that your small business majority owner who controls the company doesn't really walk off with all the money. A lot of people want to see trust on paper. The big issue, though, is that if you're in one of the protected categories of the socioeconomic categories, either a 8A, a women in small business, a service-disabled veteran in small business, or a hub zone, you can't have a single element of control. The small person who's qualifying the business for one of those socioeconomic categories has to have absolute and total control. And it could be persons or persons that meet any one of those categories. And that minority partner can't have a single opportunity to block a vote, even for extraordinary business decisions. That means if you're in one of those categories, you can't have supermajority shareholder voting requirements to protect the stockholders' investment at all. You can't block change in the organic documents. You can't block issuance of additional shares. You can't block entering into a new line of business or the addition of new members. Think about that. That small business can come and admit as many new members or stockholders and issue as much stock as they want, and you can't do a thing. So that's a lot of trust. But that's only for those protected categories. The SBA will allow small businesses that don't qualify in one of the other socioeconomic categories to have control over extraordinary business decisions. So in some instances, for small business concerns that aren't in one of those protected categories that require absolute control, extraordinary business decisions might be okay. What's never, ever, ever okay under whether that's the SBA programs or the VA programs, is control over ordinary business decisions. That means that if you are a other than small business and you want to be a minority shareholder of a small business, you have to trust that small business with ordinary business decisions, and that includes payment of dividends, borrowing money, changing employee and officer compensation. So, if the CEO of the company wants to pay themselves a whole lot of money, you can't do anything to stop that. If they want to fire everybody, you can't stop that. If they want to hire people that you don't like, you can't stop that. If they want to purchase a bunch of equipment or anything else that would be interfering with daily operations, you have absolutely no ability to stop it. The best you can do is write into your agreements, I will be consulted. And then you can raise, through that requirement, you can raise concerns verbally, but what you can't have is the legal authority to block any of those ordinary business decisions. And that's for any small business anyway. And so that's a big turnoff. I have a lot of large businesses that want to come in and invest, and a lot of times this inability to have any formal legal control does make them no longer interested in playing in the small business market. What it also means is you really should have very good business partners, so that, I think sometimes the reliance on legal documents is maybe overstated in our culture. Even I say that as a lawyer, but what's really important is that you know who you're getting into business with, or you believe you do, and you have reason to think that it's going to be successful. So now that we've covered all the horrors of affiliation, the good news for small businesses is that there's relaxed affiliation rules, and under the All Small program, a whole lot more entities can play than used to be. The program used to be reserved only for 8A small disadvantaged businesses under 13 CFR 124. That program in 13 CFR 124 still exists. It still exists under the terms and conditions that are there. They're generally the same terms and conditions, and I'll just reference a few places where they're a bit different. But that means that if you're a hub zone, a women-owned small business, a service-disabled, veteran-owned small business, or, hey, just a small business under your NAICS code, you could be a protege. So if you're interested in that, or if you're a large business and you want to get some of the small business contracts, there are some affiliation benefits to being an SBA Mentor-Protégé in the SBA Mentor-Protégé program. One is that no determination of affiliation or control may be found between a protégé firm and its mentor solely based on the Mentor-Protégé agreement or any assistance provided pursuant to the agreement. But if you're someone who wants to push that, it's not a get-out-of-jail-free card. What that means is that if you're complying with your Mentor-Protégé agreement, and if you're doing a joint venture pursuant to that agreement and you're complying with the rules, you're fine. But if there's other affiliation going on that shows that it's somehow impermissible or more than a mentor-protege, it won't stop the government from going after you and alleging affiliation. The other great advantage of this is that you can joint venture. So an SBA mentor who's not small at all can, and its protege who is small, can joint venture as a small business for any government procurement provided that the protege qualifies as small for that particular procurement, and the SBA approves the mentor-protege agreement before the firms can submit offers as a joint venture. So the protege gets the benefit of the mentor's assistance, the mentor gets to compete as a small business, and the other benefit is, we've talked about negative control, that's still going to apply to that agreement, but the mentors may own an equity interest of up to 40% of the protege and still provide technical assistance, which outside of the mentor-protege, that combination, even though that interest is below 51%, that combination of providing that vital technical assistance plus a significant ownership and interest might create affiliation outside of the joint venture. Okay, so who can be a protege? Well, here's the interesting thing. You have to be a for-profit or agricultural cooperative. I've never done a mentor-protégé with an agriculture cooperative, but they obviously have a good lobbying arm. You also have to have industry experience. So for the all-small mentor-protégé, what's interesting about that is they want to show that you're not just a new entrant in the field, so you want to show some past experience. And the other interesting fact for the all-small program is no more than 2 mentors in the business's lifetime. If you're a mentor, you're not supposed to have more than 3 protégés at a time. And also, again, you're going to be, it has to be a for-profit or an agriculture cooperative. So anybody who's on the phone with a nonprofit, for whatever reason, they decided nonprofits were going to be eliminated from participation in this program. The other key role here is, of course, the SBA. There's a lot of approvals that have to go on in this program, and the SBA must determine that the mentor-provided assistance will promote real developmental gains for the protégé, and that they determine the affiliation must not exist between the mentor and the protégé. That last point is key. If there's been an allegation that you are affiliated between the mentor and protégé, maybe even a determination by the SBA that you're affiliated, you can't get around it by saying, okay, well, I've been determined to be affiliated, so now I want the advantage of the exception to affiliation by getting the SBA approval. You're no longer, if the SBA has made that determination, you are no longer eligible for the program. And I want to do a foot stomp on this point because I am aware of small businesses who don't read these very complicated rules and think, oh, there's an all-small program. I can just go ahead and do it on my own. I don't need SBA approval. Wrong. SBA, you need SBA approval to have this exception to affiliation. And then there's a whole host of other requirements. I won't go into each of them, but I'm going to just highlight a few of them. Of course, again, we get back to SBA must approve the JV agreement if you're going to do a joint venture, and you've got to comply with your requirements for a joint venture, whether you're 8A or all small. And the separate legal entity protégé must own at least 51% of the joint venture, and the managing, the protégé employee must be the project manager. Not only must that employee be the project manager, that project manager cannot have been employed previously by the mentor. So what used to happen, and in fact SBA, I'm aware of circumstances where they actually endorse this, they would say, oh, okay, you're a mentor, that's okay, you can go ahead and help, give them some employees that are really experienced. Go ahead, that's fine, that's good. That's what we want mentors to do. Except no more. SBA has a few years back decided that was a very bad practice because it did create more affiliation than they were willing to withstand. So if you're a protégé, not only must the project manager be yours, that project manager should not have been an employee of your mentor. Go out on your own and find it. It's okay if your mentor helps you find the right project manager. It just can't have been somebody who's right from the mentor. Additionally, the protégé must perform at least 40% of the work in the aggregate at any subcontracting tier. Again, they're going to want to see that work is also substantive and meaningful. The idea is that the protégé is going to grow, not that the protégé is going to be used and thrown out after the mentor-protégé agreement ends. Okay, and just because we've talked about that it's not an exception to all affiliation, it's also not an exception to meeting your other rules that are in your small business set-aside contract if you have a set-aside. And one of the hardest ones is the limitations on subcontracts, which applies to all set-asides. And I've quoted the FAR. In the past, there's been a difference between the FAR rules on limitations on subcontracting and the SBA rules. My view has always been the FAR is your contract. You need to comply with the clauses in your contract. And so you have the percentages up there for the various categories. So services except for construction, at least 50% of the cost of the contract performance incurred for personnel shall be expended for employees as a concern. If you're going as a joint venture, then at least 50% of the cost of contract performance needs to be performed by the joint venture. So, and then, as I said at the bottom, we still have to guard against affiliation requirements. So I'm just quickly going to go over the other paperwork requirements here. Notice there's a lot of certifications here, and that's going to be something that I hit too. This is really, I think, it serves two purposes. One is that it makes sure that the SBA knows that the small businesses are sort of paying attention to where they are on the spectrum, but also maybe later on it gives the Department of Justice a certification to go after if they've gotten it wrong. So you have to do an annual performance of work report. The mentor has to certify annually that it continues to possess good character and favorable financial position, and the protege has the annual certification as to whether there have been any changes to the terms of the agreement. So there's been a recent change there's a couple recent changes I want to hit. The biggest one potentially is that the SBA is in March of 2018, which is now currently effective, issued a technical correction to the rules regarding recertification and size status. The prior rule had contained a maybe ambiguous sentence about exceptions, and based on an SBA OHA case, Analytic Strategies, which is discussed there, in that case, the SBA Office of Hearing and Appeals said, hey, look, where the language says the following exceptions apply, that doesn't mean that, if you've had one of these categories that trigger an exception, you can still go ahead if you were awarded the contract as small, even though you hit one of these categories, you can continue to perform your work. And by the way, except where the regulation says otherwise, in some instances, the agency can actually allow you to compete for new work after your recertification as small, even after you have a triggering event. And it's just that in certain instances, they can't count it as towards their small business goals. So the SBA issued this technical correction, and the concern about it is it is the most awkwardly written technical exception ever. Now it says, however, the following exceptions apply to this paragraph G. And this paragraph G stated the general rule that, look, a concern is small for the life of the contract. There were some exceptions which triggered it. And the issue then is, what does that mean? After you have a triggering event, can you still retain your contract, the contract that you had when you were small? You legitimately certified as small. Can you continue to retain that contract and the work that you already have? So it's not really clear how it's going to play out. I think that there will be less concern if it plays out that, look, as long as you were small when you got that task order, that's completely fine. You get to keep it. But if you were other than small when you got the task order, you can't continue to go after new task orders or new work once you have a triggering event where that work is being set aside for small business. I think there's still going to be some room to see where it goes, but I've at least anecdotally heard one instance where the SBA raised concerns about even allowing a contractor to retain the business at all that they already had. Hopefully that was just a misunderstanding, but I guess there's more to come on that, and some people have raised the question as to whether that's even a valid rule because they didn't go through the standard rulemaking process. There's changes to the new SBA 7A loan changes. I won't go into detail in them other than to say if you're looking to get in and acquire a business that's small, those SBA loans can give you some opportunities that are better than they used to be. The final foot stomper for me before I turn it over to Emma is going to be the potential consequences of non-compliance are real and they're significant. The civil false claims is terribly, I would say, punitive. They wouldn't use that word, but you know, if you have falsely certified that you were small, the penalties are between 11,000.2, like 11.2 thousand to 22.4 thousand per false claim, which typically means per invoice. It's also 3 times the damages, and here's the kicker for small businesses. There's an SBA regulation that says the presumptive value of the damages is the total revenues, not the total profit, but the total revenues received. Now, I've litigated with the Department of Justice some civil false claims brought under an allegation that the representation of size was false and was also met the knowledge requirement of the Civil False Claims Act, which is either intentionally false or there was a deliberate ignorance of the falsity or it was recklessly entered into. And the Department of Justice, especially if you do a self-disclosure, typically will be reasonable in its negotiation depending upon the facts. But they do have under the regulations the ability to say 100% of your revenues, not just profit, are what's false. It could be criminal action. We are aware of criminal actions that have been taken in this context. So criminal action does require a specific intent. So it's not just the more relaxed standard of the civil. And finally, you know, the suspension debarment ability, which is called administrative action, can make small businesses who say they're small that aren't ineligible to have any new work, which is essentially usually results, although it's not required to result in the termination of contracts, that usually results in that. Plus, you have to certify that you've been either suspended, debarred, or proposed for debarment in your certifications and explain it. So that, you know, these are huge consequences, devastating to small businesses, and those risks are real. And with that, I'm going to turn it over to Emma now that I've scared everybody, to talk about how it really works in small businesses.
Thanks, Becky. As I'm sure many of you have probably ascertained from the last few minutes here going over these slides, is that this is pretty complicated stuff. And I think, my number one recommendation, actually I have 2 number one recommendations, if that's allowed. I think the first one is the best thing that you can do for your company and yourself as a leader is to play by the rules. And that is the most important thing, to have good business ethics and good integrity. And in partnership with that, and this is why I say the 2 number one things you can do, is to try to avoid the problems before they occur. And so, you can have good intentions and good business ethics, but because this stuff is so complicated, you really need to have a partnership with really good attorneys. And the reason for that is because in order to try to avoid some of these problems, you can have good intentions and good integrity, but this stuff is very complicated, and you may or may not be able to navigate it yourself. And I would argue that because it is so complicated, you really don't want to be trying to interpret these rules, regulations, policies, laws on your own. You really need to get, professional legal help to navigate this stuff. And I have learned in my experience, I would say it's not always common sense. It more frequently is not common sense. A lot of these rules and policies and laws, the way they actually play out in the GovCon world is based on precedents, legal precedents. So you can go and you can read the FAR and you can try to interpret it, but you have to really understand how that law has actually been applied in practice, because a lot of those precedents really inform the way that, for example, SBA, OHA, or GAO are going to be interpreting the policy. And I think, we looked at an example on one of the slides, I think it was slide 11, the recent technical correction. I think, some of these things, not only do they have precedents, but the precedents can change, and, they can change pretty quickly, and SBA will reverse themselves sometimes. So, you really need to be closely partnered with attorneys that understand this stuff and that are following these precedents and following, these cases and these trends, so you can make sure that, you are informed as a business owner. And so I think that, my takeaway really, and I'm sure you probably have some similar views as well, because this stuff is so complicated, it's very important to really seek out professional legal assistance as you're navigating some of these issues. And, and again, stay ahead of the problem. Don't try to interpret the law on your own. I think it's very good if you familiarize yourselves with the FAR and do your best to understand it. But I think when it comes to really interpreting it and understanding, what your risk areas are, that's when you need to seek professional legal counsel to really help you. Because I think what I've learned is some companies, I think they try to apply common sense, which there's nothing wrong with that. But I think when you're getting into some of these complicated issues, it's not always common sense. And, you're better off getting that help up front than trying to correct it later, when there's already been, when you've already inadvertently gone down a path that, could have been avoided. So that is my kind of summary of, what I would recommend after 11 years in GovCon. And I will tell you that Becky Pearson has been instrumental in providing Potomac Wave with some exceptional legal guidance over the last decade. And, we've had issues ranging from protests that we've either had protests against a contract we were awarded, or, entertained maybe filing a protest ourselves. And we're guided through, the do's and don'ts of that and whether that makes sense in a given, business environment. We've had some very complex legal topics that have come up over the years that we've needed to get guidance on. And Becky has been great in helping our firm navigate those waters. So we're very thankful to her for that. And I think, it's just, I remember in business school, when I took a legal class, I just remember the professor saying, the best thing you can do is to not ever have to deal with legal stuff at all. And I think he was right. I think he was right, because I think if you can avoid it in the first place and try to, do your best to stay informed, get legal help to interpret the policies and the laws, and stay away from the pitfalls, I think that's the best thing that you can possibly do, because you really, you can't entirely avoid contract and legal matters when you're in business. And the longer you're in business, the more complex and the more range of issues the greater range of issues you'll probably encounter. It's just natural. And it's a good part of business to have, this range of opportunities, and also, instances where you're going to come across, some of these complexities. And I think, it's just part of the business. So I think it's really a good part of the business to master and to partner with a good law firm and a good lawyer. So that's kind of my 2 cents. Thank you for listening to me. Becky, back over to you.
Thank you so much for that. And we've got some questions here. I'm going to go ahead and read the question and give my answer. And Emma, if you want to chime in, you can. So the first question is a great one. In the GSA schedules world, my understanding is that the small business designation stays even though the company has become large along the way until you're required to recertify at every 5-year mark. Is that still correct? And the answer is Well, yes, it's not only at the 5-year, in GSA, essentially the 5-year mark, their options run 5 years, so that other exception for options, that's correct, unless there's also a recognition in both the GSA rules, schedule rules, as well as the SBA rules, that the contracting officer, if they want, can ask offerors to re-represent or recertify for a particular task order. That's where slide 11 comes in, because if, and the other issue there is that's not always really clear, because, you know, it would be really nice if in the regulations there was a particular form they had to use to require a re-representation or a recertification. So, you know, if they ask you to say that, you know, you're small, but there's no certification attached, I mean, well, you are small until you're required to be, you know, re-represent. So it's confusing. I think the best thing that offerors can do, because that's the other challenge, was you know those 5-year hashes, right, and you know when that's coming up. But the ability for the CO to ask for that. If you're not sure if a solicitation or a task order request is asking for re-representation, ask that question up front, because this is also where the new rule comes in. If you have grown to be organically other than small, so you haven't triggered any of those other events that might trigger it, the novation, the merger, sale, or acquisition, then, and the CO is asking for a recertification, and you're not small, you have to re-represent that you're not small. So what does that mean for the rest of your GSA contract? It probably means at a minimum that you're no longer eligible after you re-represent to compete for orders set aside under that former status. Maybe that's one that you know, if the task order request comes out and it asks that, maybe you don't play in that one. So that's really a great question and also important. And there was a follow-on point, which is some agencies require contractors to recertify when submitting a proposal or quote. Do we certify as small in accordance with the GSA schedule contract, or what our current status is? A re-representation, a recertification, if that is what the CO is asking for, that is as of your current size. So that's why you need to know, are you asking, was I small at the time of the award? Well, yes. But if they're asking, are you small now? That's a different answer, and then that triggers the technical correction and prevents you then, if you're not small, from participating for other orders that are set aside. So the second question is in the, Emma, did you have any comments on that one?
Just only that it's going to depend too on the, you know, for example, if it's on GSA, the precedent for GSA, as we've learned, is that you're small for the life of your GSA schedule contract. So unless the contract officer requires you to recertify on an individual task order basis, which is generally the exception and kind of rare, because it opens up, as we've learned, it opens up that individual agency to protest on size, because now they're the ones that are determining size versus, you know, the original determination at the GSA schedule level. So that's been one that has come up a lot, and typically it's the small businesses' size on their GSA schedule contract that determines their size for a task order, unless the contract officer requires them to recertify. That's been one we've come up against a lot, so I just wanted to clarify, you know, for everyone's benefit on that one.
Okay, great. Then there's a question here, which is in the GSA schedule environment. Does an 8A certification extend to the end of the 5-year term, or does it end at the time of our graduation from the 8A program? So in the GSA context, and this is going to be different if you just organically have grown to be graduate from the program. There are certain rules that do apply. I will I don't know, my gut on this one, I would have to go back and look at it to see if there's something specific to the 8A, but generally under GSA, as long as you met the status at the time you entered you're okay. But again, the 8A is different in that at graduation, there are some triggering events that occur. So I'm going to have to get back to whoever that is. What we'll do is we'll get back to you after that, unless, Emma, if you know that off the top of your head.
I do not.
Okay, so that's a great question. And we will get back to that individual. Are there any other questions? How does that apply when you are an 8A IDIQ? I mean, I think that the answer is that whatever the answer is that I didn't know on the first one, it'll be the same answer to 8A IDIQ. And the big difference is that IDIQ contracts, indefinite delivery, indefinite quantity contracts, they're governed by the terms of their contracts. So is GSA, by the way, but GSA is easier to know than just a question on IDIQ. Some of the IDIQs do have requirements, at least they did have requirements for re-representation at every task order. I think that's fallen out of favor in general because the reality is your reward for somebody who's successful and did a great job is no more work, right? So if you've helped somebody to grow by giving them just so much work, and then you turn around in the next year and then require them to re-represent, you know, a lot of times people who were great small business contractors found themselves pretty quickly being other than small if you do a 3-year average, and basically they found themselves with nobody else left on the schedule to do the work, which kind of defeats the whole purpose of the IDIQ. So again, IDIQ is going to be governed by its terms as well as the requirements of the 8A program and graduation from that. So with that, we have, thank you so much for listening to us today. I want to give Emma a great big round of thanks for, you know, really talking about what the realities are for small business, because it's one thing to sit up here on the legal side and talk about horror stories, but it's another thing to have to run your small business. And at the end of the day, you know, the small business program only works if people can actually operate their small businesses, and as Emma has done with Potomac Wave, really succeed. So thank you so much, Emma. And we also want to tout our next upcoming government contracts webinar, Top 10 Deal Considerations for Government Contractors. That's going to be on Wednesday, August 22nd, 2018, from 12 p.m. to 1 p.m. Eastern. Thank you so much for participating in this webinar. We don't have any other questions at this time, so we're going to sign off. Goodbye.